Well, I might start with the first scenario because it might take the rest of the time we've got this morning just to read it. I hope we've got a few personal injuries lawyers in the audience. Can I get a bit of an indication if anyone practices in the personal injuries area? Got 1, 2, 3. Oh, great.
What a silly thing to put your hands up and answer
You're in
question.
trouble now. So just to summarise this scenario, you've got a client who has a diagnosed mental illness and you've done all the right things getting to the door of court in terms of preparation, but one thing's been overlooked and you've applied for an adjournment to deal with getting one further report. The court's hasn't granted you an adjournment, so you're under a little bit of pressure. Your client, her injuries arise out of an assault, and she's a fairly damaged person anyway, but when she comes into contact with the defendant to her action, she becomes much more distressed than you've ever seen her. And you find that she's wanting to accept, she's instructing you to accept a very lowball offer from the defendant because she just doesn't want to go back into court with that man. Now, what do you do? Does anyone have a view that you should act on those instructions and accept the settlement, get the matter over and done with on your client's instructions? Anyone? Does anyone think that you shouldn't act on those instructions and have a view on what you should do?
Yeah, from the very back.
Well, I actually have one question. Is this working?
Yes.
And one suggestion, because we deal with clients of this type all the time, usually victims of crime applications, but occasionally in compensation applications. I would point out to the client, because communication is all important with such clients, that her psychiatrist is of the view, or her psychologist, whichever it was, that the settlement of the matter, or rather the conclusion of the matter, will be good for her and she'll feel better. So I think that might be useful. I'm wondering whether this is a situation in which you could request the court to provide a separate witness room or a screening court, since this is the main issue for being exposed to the defendant.
Yes, and that's certainly an excellent suggestion and one that would be helpful in the circumstances and might convince the client that they could go on with the action if you could get an arrangement like that put in place. The situation, and as we don't have any volunteers on whether you should accept the instructions or not, the situation is, it's a question of capacity here. Well, there certainly is a question of capacity here. If your client's in that sort of distressed state, while yes, it might do her a lot of good to resolve the matter and get it over and done with, it's a question of whether she is fully understanding the advice. If you're saying this is a really low offer and I don't recommend it, and she's saying take it anyway, does she have the capacity to give those instructions? Now, I think that the situation isn't actually all that clear, but Justice Bell, in his decision this year in Goddard, Elliot and Fritsch, seems to think that it's quite a clear-cut situation, and that in these sorts of situations the question is capacity. A client who is clearly distressed and is not acting rationally is probably doesn't have the capacity to give instructions. Now, those of us who practice in personal injuries or in family law or in victims of crime type matters would know that every second client's distressed when they get to court, and it's a very fine line between distress and a lack of capacity. But in the Goddard, Elliot and Fritsch decision, Justice Bell said that the question of capacity is a question for the court, and that the appropriate step to take if you've got a client who is acting irrationally and is highly distressed is to go back into the court and ask the court to assess whether that client has capacity.
It's a really difficult situation, this one, and I say it's the one that caused me to toss and turn a bit last night, because when you put yourself into this situation, just imagine it. You've got a client who's distressed. You've got an opponent who is wanting to take advantage of the situation to act in the best interest of his or her own client to pay as little as possible. You know in your heart that if the matter were argued out, you would probably do much, much better. But you've also got a situation where this difficulty which has presented itself to you can easily and quickly be resolved if you act upon the client's instructions. You've got this terrible situation, and it's in your interests, in the sense of getting rid of the problem, to act upon the client's instructions and to go home that night saying, well, I pointed out to the client the issue. Are you sure you want to settle this case? She told me, yes, I do. I don't want to go back into the courtroom. I can't face that man. And so you say, great, I've discharged my obligation. I can go home and sleep at night. This situation suggests to me that the practitioner really has to engage in a critical self-examination about the advice the practitioner is giving, because it seemed to me from this situation that even though I could safely act upon the client's instructions, I may not have discharged my duty to the client at all, and that I might have had to take some other step before finally agreeing to a settlement with my opponent. Now, what do other people think about this? What are the options that might present itself to a practitioner? I'm sure that there will be people who have been in similar situations. Thank you.
I think she's already under treatment by psychologists and psychiatrists. Aren't they the best people to assess? There's been obviously a change in her circumstances, in her condition. Because you've got people who already have her history, I would have thought they were the appropriate people to do an assessment, not even the court.
Yes, and that's a very good...
You'd put it before a judge.
Yeah.
Never met her before. I think, it's obviously a changing, fluid situation in her condition. This is a marked change, and it needs to be assessed. In a perfect world, the psychologists and psychiatrists hopefully be available to do that. It might mean that the matter has to be stood down, but I would have thought any judge would have no hesitation in allowing that to happen.
Now, before you get to that stage, though, one little twist. You say to your client, Megan, I think you're upset. I know you want to settle this case, but I want to ask Dr. Billy and Dr. Jenny to come and see you and reassess you. And she says, no, you are not to do that. What do you do then?
Well, I think that if you're asking me, Paul, this places me in a situation where I'd have to seriously consider whether I can continue to act.
Yes, yeah. And how would you handle the situation where you've properly formed that judgment, but you've got the opponent who is using the situation for all it's worth? It can smell that there's a difficulty in the opponent's camp, and you've got the judge who's got the pressure of the list. What do you do?
I would go to the judge and I would explain to the judge my situation, and then I would leave it to the wisdom of our judiciary that the judge might say, well, perhaps I might have a word to your client. That's a possibility. Say, look, this is a situation. Maybe hearing it from the judge sometimes can bring a different response from your client. It may or may not, but it's certainly something I would do, because I think in the situation that we've got, I think it's important that the judge be appraised of what the situation is.
I think that's absolutely right, and I think you would have had a much better run before Justice Bell than the practitioners did in the Goddard Elliot case. But I'm curious to know whether anyone in the room would be concerned in the circumstances, having just sought an adjournment on the basis of not having a report you want, having just been denied an adjournment, would anyone be concerned that their opponents or the court might think that this is just a bit of a dirty tactic, especially if the court comes to the conclusion that the client has capacity to give instructions and you're back to square one? Would you be concerned that you might get into trouble for applying for an adjournment or for asking the court to consider that capacity question?
Can I just make a comment on that? I probably wouldn't make that. One of the issues I think Paul touched on it was that is the conflict between the practitioner's own situation and the client's situation. So you're in a classic Rule 9 situation where you're not allowed to intermix your client's interests with your own. And the reason you're in this mess is because you got yourself there. You didn't get that up-to-date neurosurgeon's report that counsel rang you about the night before. So you lined up right in the spotlight for a possible negligence claim down the track anyway. So at that point, there's a real issue as to whether you continue to act anyway. And you've got to probably look at your situation. At the moment, you've got to look at withdrawing then because your own interests are involved and the client has to seek other representation. I would have thought no court is then going to force that plaintiff to go on unrepresented.
And Michael, does the Law Institute of Victoria have a facility where solicitors who are caught in this awful situation and who need to speak to somebody quickly to get advice or direction? Is that something?
Yeah, that's me actually. We have 3 ethics lawyers at the LIV and we do run that kind of advice call. And I get calls from solicitors at court. Yeah.
Could you just explain, Michael, how your group and what you do?
Oh, okay, well, I'm Michael Dole and I'm the acting head of ethics at the Law Institute. We have an ethics advice line service that's manned by 3 ethics lawyers. There's myself and 2 colleagues, and that's available to all practitioners in the state, whether they're LIV members or not. It's confidential and it's free, and you ring that ethics advice line. It's the number's in the Law Institute Journal. It's 9607 9336, and the call's taken normally by an admin assistant, who then, if it's urgent, will be put straight through to one of the lawyers. Otherwise, it's usually on a short callback situation. I'm not sure whether practitioners in the room have used the service. We take about 3,000 calls a year. Those calls are actually going up a bit at the moment. The last few weeks, we've taken over 100 in each week. And we do get quite urgent calls from practitioners at court saying, I'm in this situation, what should I do? It gets even more interesting when the solicitor has a different view than the barrister. So we normally, that's get the barrister to ring the Bar Ethics Committee and feed it back to us. So far I've been, time that's 2 or 3 times that's happened to be, I've come up with the same answer as the Bar Ethics Committee, so that's always good.
Yes, thanks, Mike.
It's interesting that in the Goddard Elliot case, which this scenario is based on, the barristers had actually sought a ruling from the Bar Ethics Committee, and in the context of having said, we're concerned that the client's not understanding our advice and not accepting our advice and acting in a rather strange way, had been asked to say whether they thought the client had problems with capacity, and they said, we think he has capacity. And then the Ethics Committee's decision was, you need to keep the brief and continue. And it's interesting that, I mean, they essentially put the assessment back to the lawyers about whether this client had capacity, but perhaps in those circumstances, the Justice Bell gave very little weight to the Ethics Committee's view that the brief should be retained and the practitioners should continue on, which left the practitioners in a pretty difficult position.
There's an interesting related issue that arises sometimes, which is when, in a couple of recent cases, people affected by mental illness have refused to seek an adjournment when advised either by their solicitors or, in fact, by the bench. And in those circumstances, that again raises a difficult issue about what you as the solicitor are supposed to do with a client who is refusing to seek an adjournment in circumstances where you are saying to them, I mean, it's fairly close to this. If you say to your client, you need to seek an adjournment, you do not have the reports, we cannot go on and win. And they say, no, I want to get this over with, I want to move on with this part of my life. That puts you in quite a difficult position.
Well, of course, the advantage for the judge is he or she is boss cocky of the room, and if the judge forms the view that especially where the judge has invited the plaintiff to or defendant to have the opportunity of going and get further advice, and the client says no, the judge can simply refuse to proceed with the case and give directions accordingly. So well, the case of the judge is perhaps a little easier than the position of the client, and this really goes back to the comment that you made before. And I think most judges these days would, on being told that there was an issue as to whether the practitioner, the barrister solicitor, can continue to act upon instructions, and that needed to be resolved urgently. Most courts, in my experience, would allow the matter to be at least stood down, if not adjourned, for a short period. The problem, of course, that presents is that it all has to be done in open court. We don't have that lovely sidebar facility that you do when you watch LA Law or other such gripping shows. But I think these days that most judges are sensitive to the sorts of situations that arise. And if a judge were to refuse an adjournment in that case, in that situation, I think that the judge exposes himself or herself to criticism later on. And if it really became a matter of concern, then you might want to have to take a very deep breath and go either to the Court of Appeal, if you're in the Supreme Court, or to the Supreme Court, if you're in the County Court, to seek an order requiring the judge to suspend the trial until those instructions were obtained, and you could be satisfied on an informed basis that it was proper for you to act upon a client's instructions. That takes real courage on the part of a practitioner, but it's one of the things that one must consider, just as the phone call to the Law Institute. Always keeping an eye on your own position vis-à-vis any complaint this client might make in the future. One of the particulars of the defence to the claim will be, in my view, that you sought independent advice. What better reflection of the maturity of the decision-making process of the solicitor involved if the solicitor sought an independent sounding board from the Law Institute, or if for some other reason Michael and his team weren't there, you might want to ring someone at the bar, senior, junior or a junior, who's experienced and whose opinion was worth taking into account before you make your final decision. But the important thing in my experience is always to ask and get independent advice for yourself, for your own protection. And in our state, I think that's always available in one shape or form. Sorry, cut you off.
I was just going to the reason I brought up the adjournment issue is because of a rather funny decision of the Court of Appeal recently, in which a judge refused an adjournment to a self-represented, obviously mentally ill man. He himself had said, no, I don't want an adjournment, and then it was appealed on the basis that he was obviously mentally ill. To substantiate his claim of medical negligence, he'd brought out various reports about his chakras and so on and so forth. And the Court of Appeal said that it was no part of the judge to adjourn the matter of their own motion in circumstances where the person had said, well, I want to proceed. And this was with a client who was plainly mentally ill. Now, you might say, well, it would have made no difference in the long run, given the nature of the evidence he was putting. But it's a slightly surprising decision, and I think it's one worth being aware of.
That's tough love. I'd like to read that decision. That sounds to me pretty harsh, because I would have thought most judges dispensing justice would want to be satisfied that every avenue had been considered before the judge would act upon the settlement between the parties. All settlements are premised upon a voluntary and free mind being brought to it by each party, and that must be in question in a case like that. What about we move to scenario 2? And Rupert, would you like to
Sure.
lead off on a description of this scenario?
So in general terms, you've got, an elderly dairy farmer from north central Victoria. He's come to you. He's got a certain a gentleman of mature years who has come to you, and he's got this surefire winner scheme, and he wants to invest in it. He gives you these documents. He says, just have a look over them. Tell me if there's anything wrong with them. And he mentions that he's been put onto your firm by this chap, Mr. E, who you're broadly aware of. You've done a bit of work for him in the past, some for his firm, some for him personally, but you've never actually acted on the other side of one of these transactions before. What do? Do you take them on? Do you, are there any particular concerns?
Throw this open to the floor. Frank Lynch, Barry Woods, you both commercial solicitors. What would be your response in a case like this? How do you go about responding to the approach from a potential client? I gather in the scenario that you haven't acted for this client before, but you have to weigh up whether you inform this potential client of your prior involvement. What do you do in this situation? I picked on 2 members of the group just because I see them on the beach at Mornington over the summer.
Well,
need a new holiday house.
Paul, it's probably you're an expert in house renovating and things, and it's really a matter of setting out the scope of the works at the start. So you work out exactly what your instructions are from your client. And then if you find during the course of that there may be a conflict, you'd then look at that and you'd say, well, there is a potential conflict here. How do I address that? And then you'd tick that off. And if it's one that's irreconcilable, which I can't imagine that it would be in a commercial matter, but it would be good perhaps if those issues were dealt with by somebody else independently. But there's absolutely no reason why you can't, I haven't read this in detail, I must say, but there wouldn't be a reason why you couldn't continue to act. But the important thing is, as with your scope of works, to set it out in detail, and that's going back to the retainer letter that you mentioned earlier. And it would be like your painter who gives you a quote and says, okay, here's the quote, and then he starts work and he strips something off and finds that it's really going to take him an extra couple of days to do it. How does he deal with that? Any more than you as a lawyer deal with an unseen problem. You have to line up with the client and say, there is going to be an extra cost here because this was unforeseen and we've got to get over it. So look, I'll pass over to Barry because he's much wiser than I am and not quite as elderly.
So Frank, you raise 2 things, the retainer letter and the definition of the scope of the retainer, but also in working in the facts of this situation, your sensitivity to a potential conflict and how that might be dealt with. And I gather what you're saying is they need to be addressed at the earliest stage. And what would be the extent of the disclosure that you might expect? Barry, do you have a...
I do, but before we even get to that, something like this just rings bells. It doesn't pass the smell test. There are clearly potential conflicts of interest. You don't touch it.
What about
Or I wouldn't touch it.
Work's been quiet and you're looking at that lovely boat that you'd like to buy for Christmas for your kids, and you think, look, this is work I'd like to do and I can do it well, it's right up my alley. Are there not ways of addressing the problem by just disclosure in the first letter? Would that not be the panacea?
I don't believe so. Where there's a conflict of interest, where the thing just doesn't hang together properly. I think the best disclosure letter to your client is to point out the problems that you perceive with the instructions, and just make it clear to the client that this is something that you just don't feel comfortable in doing, and that if he wants to take it elsewhere, he can. I don't think you can dress it up. You instinctively know, particularly having practiced in the bush for 15 years, and where most of the clients come in on a Friday afternoon having dropped their wife up the street to do the shopping, and they come into your office and sit there ready to waste your time, but ask you some question that they've dreamed up on their drive in, and you give them an answer and they look at you strangely and say, well, gee, that's not the advice that Noel Long gave me. Noel Long was the butcher 2 doors up. I mean, these people are smart in a lot of ways, but very naive in other ways, and sort of schemes like this are really not for people like this.
Let me ask you one other question then. You greeted with the client with this wonderful scheme, and the client's looking to you to act and to give it the tick of approval. But because you know it doesn't pass the smell test, and because you have experience of the other side of the transaction, is there a duty upon you as the solicitor to advise the client not just that you won't act because you perceive a conflict of interest, but is that the extent of your duty, or do you have an additional duty to say, hang on a minute, you should not go into this scheme for these reasons? Where does the duty stop?
Well, I think the duty extends that far. I think you need to tell the client that you're not prepared to act, and I think you need to tell the client why you're not prepared to act. I think that's all part of your job. He will leave the office disgruntled, and there are no fees in it, but that's the way it is.
And how do you handle the possibility that in telling the client why the client shouldn't go into the transaction, you might cast aspersions upon particular individuals on the other side of the transaction? I mean, you've got a defamation possibility.
Also breaching confidence.
Yeah. Mm. I think we've got a question behind Luke there.
Sorry. I'll get you to amplify that.
I suppose, let's say that just hypothetically you could draft a letter of retainer defining your scope and everything went pear-shaped, you'd be in a prime position to defend yourself, hypothetically. It still won't stop this person from making a claim against you if it all goes pear-shaped. They make a complaint, they might sue you, and you'll have to deal with the stress of that and defending yourself anyway. And in those circumstances, why would you want to put yourself through that stress in some respects?
And that's absolutely right. There are actually provisions in the rules for in commercial property transactions to actually make full written disclosure and act in a situation where you are acting for two different parties, or where you essentially do have a conflict. But generally speaking, you don't ever want to be putting yourself into that position. It's a really difficult situation to manage, and it'll often result in tears at the end and serious financial problems. Paul, I think
we'll need to finish shortly, but I just want to ask Charles Wontrop, who raises another corner of the triangle of obligations of confidentiality.
And you have an obligation of confidentiality to Australian Acorn, I think it's that. You have information from them. You cannot use that for your new client who's come to see you, and therefore you can't act for him.
What if the situation where, I'm tweaking the facts again, because of your past involvement with a client, you've acted to defend them in claims made against them by disgruntled former clients or investors or whatever, and the new client comes to you wanting to go into the same process, obligations of confidentiality exist. What about the situation where the new client might make a claim against you ultimately that you failed to disclose a fact or circumstance which, if they had been informed of that fact, would have influenced them not to go into the plantation scheme or whatever? How do you handle these things on the run?
I think you refuse the retainer to
Absolutely. I would totally agree.
Can I just say this is again based on a real case. The Money for Living scheme, which has been going on in the federal courts now for about 7 years, has resulted in at least one criminal prosecution of the director of the scheme and disciplinary action against one of the solicitors involved. So these things do happen too, is it?
Both. Yeah.
Right.
You know, when you're watching a grand final, that the game is over when the security people start walking around the boundary of the MCG, and I see at the back of this room the three security members of the Greens list have stood. I think that's a signal that the game is over. I want to thank everyone for your attendance, and I'd like you to thank Megan and Rupert for their presentation this morning.